the matter of Ayoola and Secretary of State.
Mr. Deputy.
My Lord, good morning. I appear on behalf of the appellant with my learned friends Sir Broachwala and my learned friends Miss Smythe and Miss Wakeman appear on behalf of the Secretary of State.
Yes.
My Lord, can I just check first of all that we all have the same bundle? I think everything is in order. Certainly the parties have the same bundles, but of course the great fear is that the court doesn't
Yes.
have the same bundles as we do. There should be a core bundle, which is a court-prepared bundle, a supplementary bundle.
How many pages do you think it should have?
The core bundle has 80 pages. 80.
Sorry, how many?
80.
Mine seems to have 78. I don't know what 79 and 80 are.
Mine's got
I think
78 too.
mine's a PDF version, so it might be that the pagination begins after the index.
Yes, so
So
it's the same.
That's right. Yes, it is 78 pages in the index. There is then a supplementary bundle, which is
Yes.
rather longer. It's 185 pages.
Yeah, we do have 187.
Yes, 187 is with the
187, same. Yeah.
But actually, you're quite right. It's
the
a sort of.
pagination is yes.
Yeah.
I think the pagination is wrong in the index. That means but
Yes.
No, it's because the index is paginated
Yes.
for this one and not for the court.
yeah.
So I think we must have the same thing.
It's the same thing, Ron, I think, yes, with 17 items in the index. And then, my Lord, there is an authorities bundle,
Yes.
and that should be 706 pages.
Yes.
And then, my Lords, there is the skeleton argument, the replacement skeleton argument, the replacement skeleton argument for the Secretary of State. That's the only skeleton argument I think that you need to look at as far as the Secretary of State is concerned. And then for the appellant, there is the original skeleton.
From last October.
Yes, and then there is the supplementary skeleton.
Yes.
And the amended ground of appeal.
And the amended ground of appeal, yes. So those are all the documents, and it seems as though we're all working from the same paper, which
Yes.
is a good start. Now, my Lords, there is an application to amend the ground. I understand that it's not opposed. It has been made out of abundance of caution. I think that the supplementary skeleton and the response to the respondent's notice is really what the amended ground seeks to formalise. I don't know if my Lords would like to hear me on that application.
Miss Smythe, that's right. You don't oppose it.
It's right, my lord.
In that case, we'll grant permission.
I'm grateful, my Lord. So my Lords will see that there were two grounds of appeal upon which permission was granted. One of those grounds has now become academic because the Secretary of State concedes that the Upper Tribunal was wrong on the particular facts of this case, and the Secretary of State's position is set out quite fully in a skeleton argument. I don't propose to say anything further about it. It's conceded, and there's nothing to be gained by making submissions on it. My Lord have the point in relation to the points in relation to which the Secretary of State has made the concession, and so then it's just one issue. Ground 3 as it was in the grounds of appeal, but ground 2 in terms of the grounds that are before the court, and that relates to the construction of Article 24.2 of the withdrawal agreement, and of course Article 25.2, which is dependent upon Article 24.2 because of the way in which the withdrawal agreement is drafted. The appellant accepts, pursuant to the respondent's notice, that she cannot come within Article 24.2 because the relevant union citizen sponsor was not a worker whilst resident in the UK.
That's CD, that is CD.
See,
CD is what the self-employed person has been called in the
Yes.
right, my Lord. Yes, my Lord must be right. I hadn't called it. That must be in the Upper
It's
Tribunal.
the child's stepmother.
The child's stepmother, my Lord. Yes. And regrettably, all parties failed to recognise this at the Upper Tribunal, despite proceedings being quite prolonged at the Upper Tribunal, and I was involved as well. But we all missed this. My learned friends picked it up quite properly. But following on from that, of course, one has, as the respondent's notice recognises, provision in the withdrawal agreement for self-employed persons who are in precisely the situation that the appellant is in. The appellant submits that she does come within Article 25(2). That is the issue between the parties. It requires the court to consider the proper construction of Article 24(2). The respondent says that the Article 24(2) rights are based on the Ibrahim Texera and Baumbas line of cases from the Court of Justice, and that they reflect derived rights. The appellant's primary submission is that that is wrong, and in fact, Article 24(2) and Article 25(2) reflect rights granted by Article 12(3) of the 2004 directive. That is the first issue between the parties on construction. And then the second issue is that the appellant says even if the respondent is right, the restrictions that the respondent seeks to place and that the Upper Tribunal placed on the scope of rights flowing from the Baumbas Ibrahim Texera line of cases is unwarranted. It's wrong. It doesn't reflect the findings of the Court of Justice in those cases. The withdrawal agreement, which is the source of rights that the appellant seeks to rely on, should be interpreted in accordance with its clear text. And the Velage reasoning, the Court of Appeal's judgment in Velage, in which the Upper Tribunal found the court considered that there was such a restriction on that line of the rights arising from that line of cases, ought not to be followed. It was obiter. It was not concerned with the scope of those decisions of the Court of Justice. It was primarily concerned with the scope of Zambrano rights. And it was not interpreting the withdrawal agreement, it was interpreting the regulations in circumstances where the parties submitted that the regulations went beyond rights granted under EU law.
And the restrictions are, or the restriction is, you
Yes.
don't have the right if you've got another route to remain.
My Lord, yes. That is the restriction that the Secretary of State seeks to place on. That is the restriction that the Upper Tribunal placed on the rights, and the appellant says that that is wrong. There was no such restriction placed upon those rights by the Court of Justice in either of those cases.
Either Ibrahim, is that what you're saying?
Texera or Baumbas. And Baumbas is the one that really creates the rights. Ibrahim Texera then interprets those in the light of the coming into force of the 2004 directive. If I could then start, my Lords, by taking you to the withdrawal agreement in the authorities bundle and the provisions that are in question. Page 63 of the authorities bundle. My Lord, you'll see on page 63 that we have Article 24. And in a sense, Article 24 is the key provision, although we're relying on Article 25 too. And Article 24.1 sets out very clearly, and the sub-paragraphs of Article 24.1 aren't really necessary. One can gauge the scope of rights just by the first sentence, which clearly says that workers and frontier workers shall enjoy the rights guaranteed by Article 45 of the Treaty on the Functioning of the European Union and the rights granted by Regulation number 492/2011. And that really incorporates all of the rights that previously applied to workers outside of the 2004 directive and that are relevant for our purposes today. The list of rights is then just confirmation of what these rights include. And it's subparagraph H that is in question for the purposes of this appeal, and it's set out in this way: the right for their children to be admitted to the general educational, apprenticeship and vocational training courses under the same conditions as the national of the host state or the state of work, if such children are residing in the territory where the worker works. And I'll take my lords to Regulation 492 and Regulation 1612/68 as well, so that we can see the language that's used and the way that finds itself in the withdrawal agreement. Article 24.2 is then and must be additional to rights flowing from Regulation 492/2011, because Article 24.1 clearly just transposes all of those rights into the withdrawal agreement. And Article 24.2 is very specific. Where a direct descendant of a worker who has ceased to reside in the host state is in education in that state, the primary carer for that descendant shall have the right to reside in that state until the descendant reaches the age of majority, and after the age of majority, if that descendant continues to need the presence and care of the primary carer in order to pursue and complete his or her education. It's a very specific right. It requires the worker to have ceased to reside in the host state. So it only applies in very specific circumstances, and those are the circumstances of the appellant's case. And I'll come on, I've made the submission in the supplementary skeleton. The Baumbast, Ibrahim and Teixeira cases, if one takes the facts of those cases, neither of those cases would have come within Article 24.2, because in all of those cases, the relevant worker was still resident in the host member state. And that in the appellant's submission confirms that Article 24.2 cannot have been the result of that line of case law.
So it's not a derivative right, you say?
It is not a derivative right. It's directly from Article 12.3 of the 2004 directive. And then if one goes over the page, one can see at Article 25.1 that the rights set out at points C to H of 24.1 are applied to self-employed persons by Article 25.1b. So that includes what we say is the Baumbast, Teixeira, Ibrahim line of rights. And then 25.2 is again distinct and simply applies the rights in 24.2. The respondent submits that these are new rights. The 25.2 right is a new right that the withdrawal agreement created. That would be surprising because of the purpose of the withdrawal agreement, which is not to create new rights, but simply to safeguard rights that were already in existence. And the appellant says that clearly is not correct. 25.2 is clearly simply preserving the right that was granted by the 2004 directive.
Sorry, I'm afraid I hadn't been alive to this point. I had assumed that 25.2 did create a new right. So if it didn't create a new right, where was the right before?
My lord, it was in Article 12.3 of the 2004 directive.
So you say 12.3 applied to the self-employed as well?
That's right, my lord.
Yes.
And there is, I think the Advocate General's opinion in Ibrahim refers to this. Ibrahim and Teixeira were reliant on the rights granted by Regulation 1612/68 because they didn't come within the 2004 directive. The whole point of those cases was we can't meet the directive and therefore we want to rely on the rights under the older regulation. So, my lord, if I take you next to Regulation 492/2011, working back in time, so and then we'll go back to the original Regulation 1612/68. This is at page 39 of the authorities bundle. And it's Article 10, which is on the right-hand side, about halfway down the page. It qualifies for the right, and my lords will see that the language reflects the language in Article 24(1)h. My lords will see that this right is not couched in immigration terms. It's not couched in terms of the right to remain in the host member state. It's a right of access to education under the same conditions as nationals of the host member state. And over time, the Court of Justice derived residence rights from this right, relying on the first paragraph, but also invoking the second subparagraph, which refers to children being able to attend courses under the best possible conditions.
Well, 492 grants a right to the children.
My lord, yes.
H grants a right to the parent, doesn't it? The right to have their children educated.
That is the way H is drafted.
Which isn't a reflection of 492 Article 10 then, it's something slightly different.
The language isn't identical.
Well, it's a different recipient of the right, isn't it?
One to the child and one to the parent.
If I could just, my lord, have a look at this again. So Article 10 at page 39 grants the right to the children. The children shall be admitted. And I think, my lord, I'm correct in saying that the withdrawal agreement, 24(1)h, was my lord's point. My lord is saying it's for their children, and that the language is different.
The rights given to the parent that their children can be educated in the relevant state.
Yes, and that when we come on to Baumbast and Ibrahim and Texera, what my lord will see is that the right is intended to ensure that families that move integrate fully, and that there is no obstruction to free movement within the European Union. And the Court of Justice interpreted that as being there should not be any disincentive. So, for example, if I'm thinking of moving from Germany to the United Kingdom, I shouldn't have in my mind that if I move and things go wrong with my job, my children will suffer because their education will be disrupted. And that this right that is set out in the regulation, and we'll go back to the regulation from '68, which is in the same language, has evolved over time, or has been, I wouldn't say it's evolved, but it's been interpreted over time as including rights of residence for the children and the parents.
Well, I thought that the parents had a derived right.
A derived right.
Based on the need of the child. Yes.
My lord, that is the reasoning.
Yes.
But the reasoning leads to interpreting the provision as giving that right as a necessary implication of the right granted to the children to attend education under the best possible circumstances and without under the same conditions as nationals of the host member state.
Well, what right is given to the parent in the EU regulation 492/2011 that is reflected in Article 12(1)h of the withdrawal agreement?
The derived right to reside with the child as long as the parent is the primary carer, and that is until the age of 18. And beyond the age of 18, the Court of Justice case law says that continues if the child continues to need the presence of the primary carer.
Forgive me, but Article 24(1)h doesn't talk about the right to reside.
My lord, no. So the right has been transposed as it was stated in the regulations, but it's interpreted in that way because it must be interpreted in accordance with the case law of the Court of Justice that applied prior to Brexit. And so there is settled case law, the line of cases, Baumbast, Ibrahim, Texera, that says that this right that is granted by the regulation necessarily involves a right for the parent, who is the primary carer, to continue to reside, and both parents, if those are the circumstances of the family. And so it isn't stated in that way. The way that the withdrawal agreement has decided to operate is not by, and one can understand why. The regulation was never amended. The Court of Justice interpreted the right in this way, and what the Secretary of State did is implement regulations that reflected that interpretation of the right.
The right to reside, consequent upon the right of the child to be educated. The right to reside is set out in 25(2).
My Lord, that is a different right, because that right only materialises if the worker leaves the UK or the host member state. So, for example, if a worker was in the UK and ceased work but continued to reside here, under the regulation, the worker and his children would have a right to reside. They wouldn't get that right under 24(2) unless the worker left.
And just to be clear, the Baumbast Ibrahim line of cases did not deal with the situation covered by 24(2).
No. And I'll take my lords to the facts of those cases as we go through them.
Forgive me, can I just be precisely clear on your
Yes.
submission about what right to reside arises under 24(1)H?
The right of the child to continue to reside in the host member state, to access education, even if the primary sponsor, the EU citizen parent who was the worker, ceases to work. So if the union citizen sponsor stops working, the right to reside in the host member state comes to an end. But the child, if the child is already in education, has the right to continue to access education until that education is complete.
Yes.
And derived from that right is also a right for the primary carer to continue to reside with the child until the child reaches 18, and beyond 18 if the child continues to need the presence of the primary carer.
So just to understand, in terms of Article 24(1), although it's expressed by reference to rights of workers rather than rights of children,
My Lord, yes.
you say actually the child can assert the right.
But it might actually be helpful, rather than me explaining the right, to go to the case, Baumbast, which interprets the provision.
No, I follow that, but just in terms of the difference between Article 10 of 492/2011 and Article 24 of the withdrawal agreement, even though it's framed a bit differently, you say 24(1) gives the child the right, as Article 10 did under EU law.
My Lord, yes.
And you also say that Article 10, having been interpreted as carrying with it the right for the primary carer to be here, that is also implicit in 24(1).
My Lord, yes. And what one must, and we'll come on to that, one must contrast the provision made in Article 24(2), because that only materialises if the worker leaves the UK. And so in the case of a family where the family wishes to continue to reside in the UK, Article 24(2) is of no assistance. And those were the cases that the Court of Justice was considering in Baumbast, Ibrahim and Teixeira.
24(2) only applies if the worker concerned leaves the UK.
My Lord, yes.
But if the worker hadn't left the UK, in this case, for example,
Yes.
the primary carer has the right, an implied right, under 24(1)H anyway,
My Lord,
had
yes.
it throughout.
Yes.
So 24(2) adds nothing in
To
reality
that situation.
to that situation.
But it adds something for other, and my lords will see the argument build over the cases and the Advocate General's opinion in Ibrahim in particular, where reference is made to Article 12.3 of the directive.
I'm sure that will help. But just so I understand, you get Baumbast decided in 2002 by reference to the predecessor of Article 10.
My Lord, yes.
And that didn't stop the EU giving the predecessor right to Article 24(2) subsequently, because it was presumably intended to cover different ground.
It was, as the Advocate General says, I'll take my Lords to it, it was intended to strengthen rights.
Yes.
And
That's
so the rights that previously only materialised for workers and the children of workers was now there for the children of all people covered by the directive, but only in these limited circumstances. And so for a self-employed person, if the self-employed person leaves the UK, the children continue to benefit from a right, and so does the primary carer. But if the self-employed person stays in the UK but no longer benefits from a right of residence, the 2004 directive does not grant any such right. So it's a more restrictive right. The right for workers is a broader one, but there is nevertheless a right for the self-employed and other people covered by the directive in circumstances where they leave. And that is part of, one will see from Article 12, it's part of an extension of rights for free movement rights that were brought in by the 2004 directive for family members where the primary sponsor, the primary union citizen, had lost rights through death or departure.
I do think it's unfortunate that we've got two Article 12s, the 2004 Article 12 and the earlier Article 12.
Yes, yes.
Yes.
So, my Lords, if I just continue taking my Lords to the legislation first.
Yes.
And Article 12 of 1612/68, which is the first provision in relation to these rights, and that's at page 8 of the authorities bundle. And my Lords will see that it is in identical terms to the right in Article 10 of the 2011 regulations. And if we then turn to the 2004 directive, at page 26, well, if you start at page 25, at the bottom you'll see the start of Article 12. And this article is all about retention of the right of residence by family members in the event of death or departure of the union citizen. So an entirely different scenario to the rights granted by Regulation 16.
Just tell me the page number again, would you mind?
25, my Lord.
25, thank you.
And so my Lords will see that Article 12.1 relates to family members who are nationals of a member state, the union citizens themselves. And in those circumstances, the death or departure of the union citizen who is the primary sponsor, the person that has a right of residence from which the family member's rights flow, will not be affected by death or departure. But the second subparagraph lays down conditions that must be met before such family members can acquire the right of permanent residence. And then Article 12.2 relates to the rights of third country national family members of a union citizen, but only in circumstances where the union citizen has passed away and the family members have been residing in the host member state in that capacity for at least 1 year.
That's the first sentence of 2.
My Lord, yes.
Which we're not concerned with.
We're not concerned with, but Article 12 just sets out this new suite of rights, and as part of that, we then go to Article 12.3, and again, it's departure or death of the union citizen shall not entail loss of the right of residence. So this is all related to residence rights, not access to education rights, whereas actual custody of the children, if the children reside in the host member state and are enrolled at an educational establishment for the purpose of studying there until the completion of their studies.
So, as you say it's about residence, not education rights. but it is tied to education.
My lord, yes, yes, but it's couched in terms of the right to reside if you're in education, in contrast with 1612/68 and 492/2011, which is couched in terms of access to education, with rights being derived from that right to reside, whereas this is couched in terms of you have a right to reside if you're in education.
Well,
so the emphasis is different.
But this isn't about granting rights at all, is it? It's about rights that you already have from somewhere else not being lost.
My lord, yes.
Yeah.
Yes. So you must have had the right, and then that right continues.
And the source of the right at this stage is just Article 12, or is it Regulation 12 of 68?
No, the source of this right is this is a new right granted by the directive.
No, but we just agreed it's not a new right. It's saying you don't lose a right. The right that you don't lose must therefore come from somewhere else. Where is
from
that?
the directive itself.
And where is that?
So, my lord, the scheme of the directive, I think we have the whole directive. If one goes back to the start of the directive, you have in Article 2, page 20, definitions of family members. But in Article 3, you have beneficiaries of the directive, and that includes family members.
Now you're taking this beyond what I've anticipated. So could you take it a little slowly, please, Mr.
Yes,
Manager?
certainly, my lord.
So you're saying that the right, which the Lord is asked you about, is further back in the directive.
My lord, yes.
And where are you starting? You're starting in the recitals?
Starting at Article 2 at page 20. So there you have definitions, and you have the definition of family member. And then at Article 3 you have beneficiaries of rights under the directive, which includes family members at Article 3.1. And Article 3.2 applies to extended family members as they've been identified, as they've been the terminology used in the domestic regulations. The directive uses the term other family members. But then in Chapter 2, from Article 4 onwards, you have the rights granted to these beneficiaries. Article 5 is the right of entry. Article 6 is the right of residence for up to 3 months. And then Article 7 deals with long-term residence for more than 3 months. And that article, as my lords will see, sets out conditions that must be satisfied.
And specifically, if you take, say, Article 7,
1A.
you get about 1A is for the
Workers
worker
and
or self-employed person.
Yes.
1D is for the family members accompanying.
My lord, yes. And of course, the way that EU law rights worked was that if a person ceases to be a worker, that right ceases upon the person ceasing to be a worker. So if the person ceases to be a self-employed person, that right ceases, which is why the protection granted by Article 12.3 was an important extension, because in circumstances where a person moves to a host member state, decides to pursue work there, or is self-employed, but then moves to another country, whether that is within the EU or elsewhere, the family member's residence, continued residence in the host member state is protected.
Right. So are those the provisions in the directive you are relying on in your assertion, your submission, that there was that as to the right of residence, which is being referred to in Article 12?
My lord, yes, Those are the provisions. Article 7 is the main provision.
So, in this case, who is the family member who has acquired the right under Article 7?
The child. So the child has.
Yes.
Sorry, the family member who has acquired the right under Article.
Let's
7.
take it. Under Article, you took it to Article 7.
Yes.
Article 7.1. Who is the person who has the right under Article 7.1? Let's start there.
The person who had the right under Article 7.1 was.
The relevant right.
Yes, the appellant's daughter's stepmother.
Yes, the person called CD in the
Yes.
UT decision.
Yes.
Right. And the person who has the family member who has the right under, I'm sorry if I'm taking this too slowly, but
No, my lord. I'm glad you're taking
the
it.
family member under Article 7.1D that's relevant here is who?
Is the daughter.
Right. Okay.
And so at Article 12.3, the right of residence of the daughter
Yes.
is not lost, and at the same time, the right of residence of the parent who has actual custody.
In 3.
My lord, yes.
I've got there, Mr. Manager.
I'm grateful, my lord. I'm glad because I
So
was
I'm
worried
afraid-
that I wasn't going to get there.
So I'm afraid I haven't got there yet. So I understand that the child had residence, a right of residence under 7.1D prior to the worker leaving.
Yes.
Upon the worker leaving, what existing right of residence within this directive did the mother have?
My lord, the mother did not have any right under the directive prior to what the appellant says, rights materialising under Article 12.3. And my lord is correct in that 12.3 refers to residence rights not being lost, but that is in reference primarily to the child, because the child's right then results in the primary carer's right granted under Article 12.3, and that is the way that that the directive is not drafted. And I think there is some dicta from my Lord Justice Sedley many years ago that the directive is drafted in aspirational terms rather than legislative terms in the way that one would expect legislation in England. But ultimately the effect of this, the purpose is to ensure that a child that has a right to continue in education has the primary carer with him or her, because that is the only way that that right is going to be effective.
So there isn't a provision granting the right to reside to the parent of the child.
But my lord, the appellant would say this is the provision 12.3, and my lord's concern is that it refers to rights not being lost, but that relates to the child. And although that is the way the overall provision is phrased, the clear purpose of the provision and the way that it is applied, and I'll take my lords to the regulations as well, because there is a regulation that implements this right. The purpose is clear, that the child that doesn't lose the right necessarily also results in the primary carer, parent who has custody of the child, also benefiting from the right.
So, John, I think you've just said this. So the mother didn't have a pre-existing right. You say 12.3 gave the mother a right when CD left.
My lord, yes.
So that's what you say the right arose when CD left.
My lord, yes. If I could then take my lords to the regulations that implemented both of these rights, so the rights under 24.1H and the rights under 24.2.
Before you do, can I just be clear about this? You accept that this is a right that's limited if you're right about 12.3, it's a right that only continues until the completion of O's studies.
My lord, yes.
Thank you. I'm
So
sorry I interrupted you.
No. If I take my lords to page 40 of the bundle, the authorities bundle. And this is Regulation 10 of the 2016 regulations that applied at the relevant time. And my lords will see that 10.3 and 10.4 reflect the rights granted by 12.3 of the 2004 directive. If I could ask my lords to just read those.
Sorry, so I wasn't keeping up. So 10.3
10.3 and then 10.4.
reflect the rights granted by
Article 12.3 of the 2004 directive, the provision we were just looking at.
yes, I see.
Granted, as you say, they're granted
Yes.
on your submission. Right.
So you say 4 is unqualified, reflecting the fact that the parent didn't have to have a pre-existing right.
My lord, yes. And my lords will see the way that we get to 4 is 3A Roman numeral 2 Roman numeral 4. Sorry, it should just be 3A Roman numeral 4. No, I'm sorry, I'm getting myself confused.
Isn't it
2
3?
is necessary.
Is 3B?
Yes, and then 3B. So one must satisfy 3A and 3B, and 3A is satisfied by 3A Roman numeral 2 and Roman numeral 4.
Yes, 4. Well,
because the child is
in this
child
case,
spouse.
if your client comes within this,
Yes.
she comes in it as under 4
Yes.
because she's the parent of a
Oh, yes.
child who satisfies the conditions in 3.
My lord, yes.
And you say they are
3A, 2 and 4.
And I dare say it's obvious anyway from other materials, but you say it's clear that this is implementing 12.3 because it's tied to ceasing to reside and death.
My lord, yes. And we can see then at page 43 of the bundle the regulation that implements the rights under 24.1h, which is described as a derivative right to reside.
I'm sorry, Mr. Manager, I was just making a note. What did you then say?
Regulation at page 43, we have regulation 16 of the same regulations, which implements the rights granted by Article 24.1h.
Of the withdrawal agreement.
Yeah, well, no. Implements the rights granted under the line of cases Baumbast, Ibrahim Texera, and Regulation 492/2011. But these are the rights that are referred to in Regulation 24.1h. I apologise.
So before we move on to that, can we go back to Regulation 10, page 40?
Yes.
I want to understand where this leads us, because this is defining, as I understand it, like Regulation 10, a family member who has retained the right of residence.
Yes.
So again, doesn't appear to be contemplating the grant of any right.
My lord, again, yes, my lord is absolutely right.
Same
That
problem.
is the way, that is the terminology used. But what one can see from the substance of Regulation 10 is that Regulation 10.3 reflects retention of a right by the child in this case, and Regulation 10.4 then applies that right or grants a right under the retention regulation to the parent. And often it will be that the parent has previously had a right, and so it is retained. But in this particular case, and there will be other cases like this, the parent does not have the right because of the way families make and break.
So can I just 10 defines family member who has retained the right of residence. So that's a defined term, and we know from what follows who is such a person.
Yes.
Where is the right of residence for such a person recognised in the regulations?
My Lord, we don't have any of the other provisions of the regulations in, I'm afraid, and that's not something that
No. So,
I don't think it's in dispute.
no, I'm
I
sure
will
it's not.
certainly
So you forget about the fact that the defined term includes the words has retained the right of residence. We could just as well have put in X.
Yeah.
And defined X to be such and such. And you say elsewhere in the regulations it says that X has a right of residence.
My Lord, yes. And I will try and find that provision. And my Lord, if we then go to page 43 of the authorities bundle, you have a whole host of derived rights of residence under Regulation 16, including Zambrano rights and Chen rights, which are all referred to in the Court of Appeal's judgment in Village. And it's Regulation 16.3 and 16.4 that the appellant submits, and I don't think it's in dispute, implements the rights reflected in the Bambas Ibrahim Texera line of cases. So 16.3 is the right for the child who is in education. One can see that the requirements are very different. There's no departure or death requirement, but there is a requirement that the parent must have been a worker, the EA national parent, and 16.4 then in granting a right to the primary carer includes a requirement at 4B that is not present in Regulation 10.
So you have to satisfy one of the criteria in 2 to 6.
My Lord, yes.
And in this case, you say,
Not in this case, my Lord, but in a case where one is relying on Baumbas Ibrahim Texera rights, so that line of case law, it's Regulations 16.3 and 16.4 that implement those rights in domestic law. And of course the appellant's submission is that they're being treated differently under the regulations because they are different rights.
Did you not say accept that these rights did in fact exist in the case of the mother in this case?
The appellant does, but the appellant's primary submission is that the right under 25.2, which relies on 24.2, is the right under Regulation 10. That is the right that she's entitled to primarily.
That arises on exit of the worker.
My lord, yes.
But-
Those are circumstances. But
This is a case where, in fact, the mother had a right under Regulation 16, reflecting Baumbas going back to.
my lord, no, because Regulation 16 requires that the EU sponsor was a worker, and the EU
Yes.
sponsor in this case was not a worker. So the way that the respondent's case is put is that 25.2 and 24.2 reflect the Baumbas Ibrahim Texera line of cases, but 25.2 grants a new right that didn't exist before. And that in any event, even if that is a new right that's granted, the appellant cannot benefit because there is no compulsion on her to leave the UK. That is inherent in being able to satisfy that right, and the reason there is no compulsion on her to leave the UK is because she has a right of residence under domestic law already at the moment. And that is the difference between the parties. The
Yes.
appellant would say that that is not a requirement of the Ibrahim Texera and Baumbas line of cases, so that even if the court were to find that in fact 24.2 and 25.2 did reflect the Baumbas, Ibrahim and Texera line of cases, the reason that the Upper Tribunal gave for refusing to recognise that the appellant had a right under 24.2, now 25.2, is that there was no compulsion on her to leave. And the appellant's case is that that is not a requirement in the withdrawal agreement. One looks at the text, there is absolutely no reference to a compulsion to leave, and that was not a requirement in the Baumbas, Ibrahim Texera line of cases.
Well, that's a core part of the case, which we'll come
That's
on
a
to.
core part of the alternative case.
Yes.
If my lords are with the appellant on the first submission, one doesn't need to go into the second submission. But if my lords are not with the appellant on the first submission, then one goes to the second submission, the secondary way that the appellant puts the case.
So there are in principle two issues. One, what would the position have been under EU law?
Yes.
And
What
two,
is the 24.2 right? Is it... as
Yeah,
a res-
but can I just separate it out for a moment? Leave aside the withdrawal agreement. Where would your client have been under EU law? And second, is it different because of the withdrawal agreement? No?
Well, the appellant would say that we're really just concerned with the withdrawal agreement. And the withdrawal agreement clearly reflects rights that pre-existed under EU law. The appellant's primary submission is that, well, when one looks at the withdrawal agreement and the text of 24.2 and 25.2, the appellant clearly comes within it. One
That's
is
your, that's your first point.
That's
the
the
first
first
ground
point.
is look at the wording, the appellant satisfies that.
and that's supported by the reasoning for that text being there, which is that this reflects rights under 12.3.
So can I turn it round? I did it EU law and then withdrawal agreement. You say withdrawal agreement, but if Ms. Smythe persuaded us that the withdrawal agreement was intended to go no further than EU law, you still win because you win under EU law.
My lord, yes.
Because the tribunal's interpretation, the restriction, was wrong in law.
My lord, yes. That's right. And we all got it wrong at the tribunal, so we were looking at 24.2, which we should not have been. We were also all working under the assumption that 24.2 reflected the Baumbas Ibrahim Texera line of cases. So the submissions before the Upper Tribunal were to the effect that the reasoning in Velage was obiter and did not apply to the Baumbas Ibrahim Texera line of cases. The position has moved on now because there has been a re-examination after the respondent's notice, a recognition that 24.2 does not apply, but in response to that, a re-examination of the entire structure of 24 and 25, and the appellant submits, well, actually, 24.2 isn't the Ibrahim Texera Baumbas line of cases at all. It's a different one. It's Article 12.3 of the 2004 Directive.
So the reason you've taken us, going back to where we've got to in the trawl, through the legislation,
Yes.
you've taken us to a Regulation 16 because you say that is where UK regulations incorporate the CJEU case law, Ibrahim, etc.
My lord, yes. And Regulation 10 is where the domestic regulations incorporate the 12.3 line, right? And that, as
Well,
my lord
subject to the
concedes-
subject to the point that we were arguing earlier that the wording is different.
retention. It's the same wording, the same difficulties as the way in which it's expressed in 12.3 because it refers to retention, but the clear purpose and the clear way that the regulations work is that there is retention by the child, but not necessarily by the primary carer, because the primary carer just gets a right on the back of the child on the basis that he or she is the primary carer, with custody. Custody is the word used in the regulation. So if the parent does not have custody and is not the primary carer, that right lapses. If I could then take my lords to the judgment in Baumbas, and take my lords to the Advocate General's opinion first. It's, the reported case includes the Advocate General's opinion, and the part of the no, I'm sorry, my lords, I just wanted to take to the judgment of Baumbas. It's at page 101.
You're coming back to the withdrawal agreement later, are you?
My lord, yes, I wanted to go through the cases so that my lords can see how the rights under 24.1h, which reflect 492/2011 Article 10 and Article 12 of Regulation 1612/68, were developed by the Court of Justice. That's an essential part of the respondent's case, and it's important for the appellant also to develop the distinction between 24.2 and 24.1h. And so Baumbas and Ibrahim is what I was intending to refer my lords to. I don't think it's necessary to look at Texera because Ibrahim and Texera essentially say the same thing. They're judgments made on the same day by the Court of Justice. Looking at Zambrano as well to contrast the way that Zambrano gave rights as compared to the rights that were recognised in Ibrahim, Texera and Baumbas. And then also looking at Village, because Village is a case where, albeit obiter, and considering the regulations, not the withdrawal agreement, the Court of Appeal said something about the nature of rights under Baumbas, Ibrahim, Texera. So if I could take my lords first to Baumbas, and the judgment begins at page 101. The facts begin at page 104. There were two cases before the Court of Justice. The facts are set out at paragraphs 16 to 27. If I could invite my lords to quickly look at those facts, the only reason being, or my lords might just want to hear my submission on it, the submission is that the facts clearly show that the worker in question was resident in the UK at the relevant time. This is not a case where the worker had left the UK. And that is important because the appellant says that Baumbas, Ibrahim, Texera, all of those cases would not have succeeded under 24.2 because the relevant worker had not left the UK.
I'm just standing up out of fairness to my learned friend so that he can address paragraph 18, which says that Mr. Baumbas had left the UK and gone to work in China.
My lords, yes, he was working, but he was still resident. And that's why one of the questions referred was whether he had a right of residence in the UK. So this wasn't a case where he'd left. He was clearly travelling and working overseas. But he was resident with the family in the UK, and my lords will see that I think it's the second question.
So before we come to the questions,
Yes.
perhaps we should look at this. So the key paragraphs are, you say paragraph 18, or Ms. Smythe says paragraph 18, and in the R case, well, perhaps we should just read the paragraphs as you say. We'll do that.
My lord.
Sorry, which paragraphs are you reading?
We were asked
It's
to
paragraph
look at 16 to 27.
Up to 27. My Lords.
Yeah.
We'll see then at paragraph 28 the questions in common to the two cases that were referred to the Court of Justice.
And it is best to look at that account of the questions, because normally it turns out the question is treated slightly differently.
Yes, and I'll come on to the reasons for it. But my Lord will see that the questions related to whether children who are in education had a right to reside pursuant to Regulation 12 of 1612/68, and whether Regulation 12 of 1612/68 also necessarily required a right of residence for the primary carer. And my Lords will then also see from paragraphs 29 to 38 a preliminary issue being considered by the court.
Do we need to consider the exclusive questions to the Bombast case or not?
My Lord, no, but only to the extent that that question shows, and the facts show, and the nature of the questions referred show, that the court was not dealing with a case where it was asserted that either of the parents who were workers had left the UK. The entire family units were still all in the UK. And Mr. Baumbast, although he was working overseas, was seeking a right to reside in the UK. Him and Mrs. Baumbast owned a home together, and this was clearly a family that was living together.
And the question, 3A, would seem to be directed to the fact that he would no longer enjoy the right of residence.
Yes, so he was seeking a right, and it was asserted that he didn't have a right. So the question was, does he have a right directly under the treaty? And I think, I'm not mistaken, that the answer to that was, well, it would be disproportionate not to recognise a right for him, albeit that he did not. He was no longer a worker. So the preliminary point considered from paragraph 29 onwards is relevant because it's clear that in Baumbast, the two primary carers who were seeking a right derived from Regulation 1612/68 did, at the time of the proceedings before the Court of Justice, already have a right under domestic law. And they'd both been granted indefinite leave to remain in the UK. At paragraphs 35 and 36, the court considered that the questions were still admissible because the leave that was granted under English law, and the question of rights conferred under community law had not been resolved.
The court also read paragraph 37 as well. I apologise that we haven't sidelined it.
Let's read 35 to 37.
My Lords, then the findings are set out from paragraphs 47 onwards.
This is in relation to the first question.
My Lord, yes, the first two questions. No, so it's I think
As
my
they've
lord, it is
expressed
the
in the first question.
Yes, and the second question. That's right.
Which paragraphs do you want us to read? The sideline ones.
My Lord, yes, and if I could in particular refer my Lords to paragraph 52, because again in relation to the rights of the children, it adopts the common methodology used by the Court of Justice in considering what might happen in circumstances where the legislation is interpreted in a different way.
Yes. So we better read those paragraphs. At this stage, we're dealing with the right of the child, are we?
Yes.
So we'll read 49 to 50. Well, we better read on, have we? Well, shall we stop at 52 or shall we go on?
My Lords, there is then the second question.
No, well, let's read 49 to 52.
My Lord, very well.
Yeah, I see. Paragraph 49 confirms both that Mr. Bast was no longer working in the United Kingdom and also that he continued to reside there.
And my Lord,
And your point is expressed in terms of disincentives to freedom of.
my Lord, yes, which is the common methodology.
Yes.
And one looks also at paragraph 56, which expressly states that the nationality of the children is irrelevant. And then one finds the answer.
Sorry, let me just read 56. I mean, I suppose just picking up that point, they're certainly saying it doesn't matter if you're a national of a non-EU state. They're not actually specifically dealing with the question of whether it makes a difference if you're a national of this state.
My Lord, no. But what we would say, what the appellant would say, is that when one looks at the source of the rights, whether one is looking at the Regulation 12 of 1612/68, Article 10 of 492/2011, or the directive, or the withdrawal agreement, or the regulations, there is absolutely no specification of nationality, because nationality is irrelevant, because the right flows from the fact that the child is the family member of the union citizen.
And specifically, I mean, we're dealing with the rights of the child at this stage, but insofar as the right of the child is derived from disincentivizing the parent, the same disincentive applies even if the child has acquired local nationality.
Because domestic law, in terms of what rights the child would have to continue education, might well not coincide with the protection afforded by union law, European Union law.
This, forgive me if I'm missing the point, Mr. Banerjee. Paragraph 56 is about children who are not for themselves citizens of the Union, isn't it?
As to whether the fact that children are not, so that's obviously one of the issues that is being addressed in that paragraph. But the point is that the paragraph clearly states, and it is clear from the text of the relevant legislative provisions, that the provisions grant rights irrespective of nationality. The only requirement is the relationship to the worker. And of course the judgments are littered with references to these provisions not being construed restrictively because of the nature of the rights.
So you say that the answer, the way in which the answer is phrased in 56, is not just relevant to the question posed there, whether the fact that the children are not themselves citizens of the Union can affect the answer to the first question, but has the more general application that you assert.
My Lord, it supports the appellant's submission that when one looks at the text of the provisions and when one looks at all of the cases that interpret the provisions, the nationality of the child is never a crucial matter. It's irrelevant. What is relevant is whether the child is the child of a person that whose rights the directive or the regulations are seeking to give effect to, because that is the source of all of these rights, ensuring that there is no obstacle or removal of obstacles to free movement for union citizens who are workers or self-employed persons. So the relevant point is, are you a family member of that person? And if you are, then we need to give equal protection irrespective of nationality. That's whether you're a union citizen, whether you're a British citizen, whether you're a third country national family member. Because if we don't, we are disincentivizing free movement. And so one can see that there would be a disincentive if a union citizen who has a child that is a third country national and a child who is a British national, which does happen. I think one of the cases might have that scenario, albeit not in relation to the UK. I think Baumbas had a Colombian child and a German child. The nationality is irrelevant. What's relevant is the family unit should be able to move freely, and that freedom includes taking away the uncertainty of what will happen if my circumstances change when I move. So when Mr. Baumbas moved from Germany to the UK, the reasoning is that there should not have been a disincentive in the form of a concern that if things don't go as planned or things change in the UK, my children's education will be disrupted because we will lose the right and we'll have to move back to Germany or move somewhere else. And that is the ultimate protection. Ultimately, that is what the regulation is seeking to protect. And that results in rights for the children, and it also results in rights for the primary carer, because without that right, the right is ineffective. It again provides disincentive, because if you're married to a third country national and you move, your concern is going to be, well, what's going to happen to the children? What if something goes wrong? What if I leave? They won't be able to stay. And that is really what this provision has been interpreted as seeking to do.
It may not be relevant. Was the child in this case ever a part of a family unit, including the worker in this case?
My Lord, I think yes. Yes, she was.
Depends how you define family unit.
Yes, I would need to double check the facts.
The child has always resided with your client. Your client has always been the primary carer, I think.
I think that might be right, Mayor. We will check, because the sort of over the course of the appeal through the tribunal system, the detailed facts have almost been lost because we've been so mired in the effect of the legal provision.
Were there any proceedings in the family courts between those parents?
Again, my Lord, I have to check. But I think that the agreed position, certainly before the Upper Tribunal, and I'm sure it is still agreed here, is that the appellant meets the requirements on the face of it of Article 24.2. The question is whether the fact that she has a right of residence under domestic law defeats that right. That's the question. So the specific factual background has not been at the forefront of certainly my mind, because we've been focused on the impact of the legal provisions, and this is the key sort of battleground area. Does the fact that I have a right under domestic law mean that I do not have a right under EU law, under the withdrawal agreement now?
So far, we've been looking at the right of the child. The second question comes on to the right of the parent.
My Lord, yes.
Or the right of the child to have the parent, I don't know.
Yes. And the findings, my Lord, are at paragraphs 68 to 75. Perhaps I can invite the court to read those paragraphs before I make any submissions. my lords will see that at paragraph 71 the same methodology is used, disincentives, and the word at the end of paragraph 71 that is used, which is in my submission relevant, is that the word might, so that if the parents were refused the right to remain, that might deprive the children of a right which is granted to them by the community legislature. The same methodology of considering possible disincentives.
Just pursuing the disincentive question. Does paragraph 71 really refer to disincentivizing, but maybe paragraph 68 does?
My Lord, yes. So paragraph 68, I would submit, my Lord, is a positive statement of why it positively is important to ensure that families can be secure in the host member state. And then paragraph 71 refers to the possible consequences to a child's education if the primary carer is not permitted to remain. And then paragraph 73, by reference to the second subparagraph of regulation, Article 12 of Regulation 1612/68, states that pursuing education under the best possible conditions necessarily implies that that child has the right to be accompanied by the person who is his primary carer. And that is without any reference to the possibility that the parent might have to leave being relevant to that analysis. So it's couched in terms of the child has the right, and a necessary implication of that right is that the child has a right to be accompanied by the primary carer.
And then by 75 it turns into a right of the parent.
My Lord, yes. And there is no reference in paragraph 75 to a requirement that a parent or a child show that if that right is not recognised under EU law, there would be a compulsion to leave, which would mean that the child would not be able to remain in education. That whole analysis is by then gone. The analysis was only relevant to reaching the conclusion. And of course, the court was aware on the facts of this case that Mrs. Baumbast and Mrs. R were under no compulsion to leave because they had been granted indefinite leave to remain. And I will take my lords to Zambrano, but my lords will see that the way that the rights are derived in Zambrano is very, very different. And the reference to the compulsion to leave is expressed in the final ruling as well. So that it's clearly not just reasoning that leads to an interpretation. The interpretation itself is based on a compulsion to leave being an integral part of the derivative right.
Does the judgment say anywhere in terms, or directly or indirectly, that the right arises irrespective of the fact that the caring parent has a right to remain?
My Lord, no.
Another right to remain. It doesn't say that in terms.
It doesn't say that in terms, but if one goes back to the preliminary point, the court was clearly aware of that. And what I would say is that in the preliminary point, the court did say that the right under community law needed to be resolved independently of rights under English law, so that if community law rights were tied in with domestic law rights, so that if domestic law right existed, community law right did not exist, one would expect the court to have said that somewhere. But what it says at paragraph 36 is that rights have been granted under English law, but that leaves open the question of rights under community law. So that, in my submission, clearly envisages that one could have two rights, a right under domestic law and a right under community law.
Paragraph 36, where the question is posed in 36.
And paragraph 37, which my learned friend asked my lords to read as well, that is a different consideration. It starts with the word equally. So it's not something that is required. 36 is freestanding, 37 is another. reason why the court went on to consider the questions. And my lords, it is not unusual for it to operate in that way in any event. A person could have a domestic law right. For example, if we were to assume that EU law rights still applied, if a person is here as a skilled worker and has a domestic law right to remain for, let's say, the next 2.5 years, but then marries a union citizen, it cannot be said that the right flowing from community law, because of marriage to a union citizen who is a qualified person, would not materialise because he already has a domestic law right. So that the principle that they are mutually exclusive in my submission is wrong unless it is part of the way in which those rights materialise, which it is in Zambrano. It is not, we would submit, in the Baumbas Ibrahim Texera line of cases. If I could then take my lords to the case of Ibrahim, and take my lords to page 130 of the authorities bundle. Here we're in the Advocate General's opinion, and if I could ask my lords to just read the paragraphs 29 to 32, because here we have reference to Article 12.3 of the 2004 directive.
Let's do that.
My lords, will see that halfway through paragraph 32, if we look at page 131, next to C in the side column, express reference is made to the strengthening of the rights that were granted under 1612-68.
If one can sort of get through that sentence, which
Yes,
has a very long bit in the middle.
Yes, my lord, it is, and one has to look at the punctuation to see exactly what's going on.
Yes.
But what it does eventually say is that that right has been strengthened through the retention of right of residence. It strengthened the right of children of other union citizens to continue their education in the host member state in certain circumstances. And that is what 12.3 does, and that must be, in my submission, reflected somewhere in the withdrawal agreement, and we say that it is reflected in 24.2 and 25.2. The judgment then begins at page 135, facts are set out at paragraphs 15 to 19. And the Advocate General's opinion already says this, but it's clear that the directive did not apply in this case. And the facts also show that there was no question of Article 12.3 of the 2004 directive applying, because all parties were resident in the UK at the relevant time.
Yes.
And the court then reformulates questions 1 and 2 at paragraph 25.
Yes.
At paragraphs 29 to 31, you have the recitation of the findings in Baumbast. And at paragraph 31, that paragraph ends with the necessary implication that a child has a right to be accompanied by the person who is his primary carer.
Sorry, which paragraph were you then referring to?
My Lord, it's paragraphs 29 to 31, and it's the end of paragraph 31 which repeats the necessary implication reasoning from Baumbast. Paragraph 48 is interesting and important as well in my submission, because what it does is, I think, gives an answer to why Article 25.1 incorporates the 24.1h right. So, whereas the respondent's submission is that Regulation 1612/68 and then 492/2011 only applied to workers, and therefore the rights derived in Baumbast, Ibrahim and Texera did not apply to self-employed persons. It might be that in Article 48 we have an answer to why those rights find themselves in Article 25.1 of the withdrawal agreement, because the court refers to Article 24.1 of the directive already incorporating the equal treatment element of the 492/2011 Article 10 right into the directive. But that is not crucial for the appellant, it's just something that
Would it be helpful to follow the argument if we read at this stage the whole of the sideline passages? Miss Smythe may be able to come back to some of these.
My Lord, yes, certainly.
You understandably, you're taking us.
Yes, I'm emphasising what I want to emphasise, my
I'm
Lord.
not accusing you of Ireland hopping.
Certainly, my Lord.
Okay, thank you.
So at any rate, at this stage, they're saying, well, 2004-38 doesn't cover the ground. You still have
those
the old-
existing rights without any fetter. In fact, the 2004 directive reinforces and strengthens those rights by extending them in certain circumstances to others. And paragraphs 57 to 58 confirmed that Article 12.3 did not apply on the facts of this case. But what it does say at 58 is that that provision illustrates the importance, the particular importance, which the directive attaches to the situation of children who are in education in the host member state and the parents who care for them. And my lords, what Ibrahim and Teixeira in my submission did was simply reaffirm that Baumbas continued to be good law after the coming into force of the 2004 directive. The 2004 directive did not water down those rights. Those rights continued to apply without any qualification based on certain of the provisions in the 2004 directive. The requirement to have sickness insurance, etc. If I could then, my lord, I don't think I need to take my lords to Teixeira because it essentially covers the same ground. If I could take my lords to the judgment in Zambrano.
Just before you do, did you? I thought you said in opening that at the EU level, self-employed persons have been included within this regime, alongside workers.
In Article 12.3 of the 2004 directive, so that applies to self-employed persons. It applies to anyone who has a right of residence under the directive. So that could be a self-sufficient person as well, or a student.
Had the right, the derived right, the right derived from Article 12 of the 1968 regulation, been extended to self-employed persons as well or not?
My lord, no, not in so far as it is relevant. Well,
there was the case of CHOP, wasn't there? If that's how you pronounce it.
That said that the regulations did not apply.
Yes.
So CHOP said that regulations 1612-68 and 492-2000, I can't remember which regulation it was looking at, but it clearly said that that regulation did not apply to self-employed persons. The argument was made that worker included a self-employed person. The Court of Justice rejected that. What the Court of Justice did not do in that case is look at whether the 2004 directive extended those rights. That was not an argument that was made, and I think, again, the 2004 directive might well not have been applicable, and that case was also disposed of in a different way that meant that the applicants continued to benefit from a right to reside.
What about the...
Sorry, go on.
What about the Court of Appeal decision, Rabkova?
My lords, I've not...
Did that only extend to the regulations, or did it also include the directive?
The Court of Appeal's decision in Rabkova. Rabkova. My lord, I haven't, to be entirely honest, considered that issue. I'm looking at the case at page 410. And again, what that one can see from the summary of the case at 410, that the Court of Appeal was looking at 1612-68 and 492-2011, the regulations, not the directive. And the appellant does not submit that a self-employed person comes within the regulations. Whether a self-employed person comes within the directive and the directive extends those rights is not a matter that I think the court needs to be concerned with, because one is now looking at the withdrawal agreement. But if the court is concerned with an explanation for why Article 25.1 incorporates the right particularly identified at Article 24.1h, the answer might be at paragraph 48 of Ibrahim, which I referred my lords to, because there the court seems to be saying that those rights have also been incorporated into the directive by virtue of Article 24.1. But of course, incorporation into the directive means that those rights are subject to the directive. The argument being made in Ibrahim was that we can rely on the primary right, which predates the directive and is not subject to further provisions of the directive, because in Ibrahim and Texera, the applicants were reliant on benefits, and the cases were about access to benefits, and the directive was very careful to ensure that there should not be reliance on public funds. And so there isn't an answer to that, but I think paragraph 48 might give us an answer. The appellant would say that the withdrawal agreement makes provision for those rights, and that must mean that those rights did pre-exist for the self-employed. We do not accept that the withdrawal agreement provided for new rights. There's no basis in terms of any materials that would support such a submission, and it would be entirely contrary to the purpose of the withdrawal agreement. The explanatory memorandum, or I think the Commission's explanatory note that is referred to in the respondent's skeleton argument, doesn't really assist and isn't really very clear. We would say that there are no new rights, those are all pre-existing rights, and in any event, the right that the appellant relies on is primarily a right under the Article 12.3 of the 2004 Directive.
So just circling back one moment, in terms of the extent to which any of this would apply to the self-employed, you say, at any rate on the face of it, subject to equal treatment or whatever, 1612/68, 492, 2011, those didn't apply to the self-employed.
My Lord, no. If the directive incorporated rights by virtue of Article 24.1, that is not something the appellant relies upon, but it might explain why Article 25.1 expressly incorporates 24.1h as a right that a self-employed person, the children of a self-employed person, can rely on.
And in terms of Article 12 of 2004-38, you say, well, that could extend to the self-employed. It just protects whatever rights of residence there were.
My Lord, absolutely. It extends to anyone with a right of residence under the directive. So any child of a union citizen who has a right, and that right could be as a self-employed person, as a worker, as a self-sufficient person. It could also be as a student.
Yep.
The right isn't qualified by any requirement that you must have exercised a certain kind of right. If I then take, my lords, to the judgment in Zambrano, which begins at page 227, paragraph 36, page 233, you have the question that was referred. And my lords will see that the question that was referred asked whether a right of residence was conferred upon a relative in the ascending line of a minor European Union citizen.
Paragraph 36.
My Lord, yes. And then paragraphs 42 to 44 set out the reasoning, but the reasoning, if I could ask my lords to read it rather than make a submission. Yeah.
Which paragraph number?
42 to 44, and my lords, if we just read on to 45, which gives the answer.
Yes.
My lords, the language of the court's reasoning contrasts with the question that was asked. The question asked whether there was a right. The court's reasoning talks about what a national state cannot do. Rather than the recognition of positive rights for such persons, because of the very unique scenario in which these rights have been recognized. The assumption that the child would have to leave the territory of the EU is central to the existence of the prohibition on what a member state can do in such circumstances. And one can see that it also forms a part of the answer at paragraph 45. The answer is qualified. So the answer is couched in terms of what a member state cannot do. You can't refuse a right, not that you must grant a right, because there is a right. You cannot refuse to grant a right of residence and a right to work, insofar as such decisions deprive those children of the genuine enjoyment of the substance of rights attaching to the status of European Union citizens. So the way in which the court has arrived at its decision and the interpretation itself is, in my submission, very different to the language and the reasoning used in the Baumbast, Ibrahim Teixeira line of cases. And that reflects the fact that in Baumbast, Ibrahim and Teixeira, the court is recognizing positive rights, albeit derived from provisions in the regulations. Whereas in Zambrano, what the court is doing is saying, well, in order to safeguard the child's rights, a state cannot do this, but only in these circumstances. Of course, that has then been interpreted in further cases from the Court of Justice and in domestic case law, and we now know it's confirmed that one simply cannot say I have a right because I'm the parent of a union citizen child. One has to go on and establish that not giving me a right would result in the child having to leave the territory of the EU. That reasoning, and in particular its incorporation into the answer, into the very right that is recognised, is entirely absent from Baumbast, Ibrahim and Teixeira. And my lords, so having gone through the cases, I come back to the submissions and the propositions that the appellant advances.
Are you going to take us to
Village?
Village, yes.
My lord, I can, although we have made full submissions on this in the skeleton, but the essentially, if one looks at the judgment of Lady Justice Andrews at page 541 of the bundle, my lords will see at paragraph 1 the issue that the court was concerned with, which is the interpretation of domestic law, regulation 16.5c, paragraph 8, quoting from the judgment of the Supreme Court in Patel, that echoes the appellant's submission that the Zambrano right has at its heart the compulsion to leave, whereas these rights that the appellant is concerned with, whether it's Ibrahim, Teixeira and Baumbas or the 12.3 right, these are positive rights by reference to the need to ensure that children can continue to stay in the host member state. At paragraph 13, again, the issue in the appeal is set out, and it's again by reference to 16.5c of the regulation. And at paragraph 15, again, the conclusion of the court relates to the interpretation of regulation 16.5c. The reference to Ibrahim and Teixeira and Chen is at paragraph 23 and 24. And it is a reference to the domestic regulations containing the same provision, that there should be a compulsion to leave if a right were not to be granted. My lords, that is also referred to at paragraph 33. And it again refers to the way in which this has been expressed in domestic implementing regulations. And then you have at paragraph 35 a case that was put to the Court of Appeal. My lords, the remainder of the judgment relates to considering the regulations in the context of Zambrano rights. You have a further reference to Ibrahim and Teixeira at paragraph 50. There's also at paragraph 57, again, a reference to the Zambrano right being a right of last resort, which is not, in my submission, the way that one could properly describe the rights granted in the Baumbas, Ibrahim Teixeira line of cases, or by Article 12.3. The ultimate conclusion in Village is that if there is a right of residence under domestic law, then the Zambrano right cannot bite that was by reference to interpreting the domestic regulations. The Upper Tribunal extended that reasoning because of the reference to Chen, Ibrahim and Teixeira and the reference in the judgment to the fact that that is the way that these rights have always been expressed in domestic regulations for all these derivative rights cases. The Upper Tribunal found that that must be the case when one is applying Article 24.2. The appellant's first submission is that Velage was not concerned with the Baumbast Ibrahim Teixeira line of cases. Secondly, it was interpreting the domestic regulations, not EU law. Thirdly, it was not looking at the withdrawal agreement. No submissions were made as to whether what was said in relation to the way the regulations have always treated Ibrahim Teixeira Baumbast rights, whether that was correct or not, simply is not an issue that was before the court, and it's not something that was addressed by the court. The remarks regarding Ibrahim Teixeira were clearly obiter.
Which particular remarks do you say were obiter?
The remarks relating to the Ibrahim and Teixeira.
Where precisely, please?
Just bear with me, my lord. My lord, we have paragraph 50, which treats the Chen Ibrahim Teixeira derivative rights in the same way as Zambrano derivative rights. In this context, in any event, the compulsion to leave the host member state.
So is it simply the passage in brackets, parentheses, in paragraph 50 that you say is obiter?
As I read the Secretary of State's skeleton, they rely on paragraphs 49 to 50. So I suppose from your point of view, you need to say, well, there's nothing in 49 or 50 which is ratio in a way that affects my case for the appellant.
My lord, it must be the bit in parentheses, because the rest of 4950 deals with the situation of somebody seeking to rely on a Zambrano right. What the bit in parentheses does is suggests that the same reasoning applies to the Chen Ibrahim Teixeira line of cases. We're not, of course, concerned with the Chen case, so it's Ibrahim Teixeira and Baumbast. So that bit in parentheses in my submission is obiter. That's really the part from the discussion. There is in the previous parts of the judgment where the court sets out the history of the provision, paragraph 33. Now, it is obiter in the sense that there was no need for the court to consider what provision was made for Ibrahim Teixeira and Chen rights. But it is also, in my submission, irrelevant to the issue that the Upper Tribunal had to deal with, because it is
Domestic
clearly...
law.
My lord, yes. And my Lord, paragraph 23 as well, where 24 is again domestic law. 23, judgment states that Ibrahim and Tixera concerned the situation where a child of an EU citizen who worked or had worked in the relevant member state would be unable to continue to be educated in that state unless their primary carer were granted a right to reside there. My submission, that is not an entirely accurate reflection of the judgments in Baumbast, Ibrahim and Tixera, and I've already taken my lords to those judgments. That reasoning was part of the court's reasoning, part of it, in reaching its conclusion. The court also said that it was a necessary implication. Of course, eventually, when ultimately the court derived the right, that right was not couched with any caveat that there must be this compulsion to leave, and that unless the primary carer were granted a right, the child would be unable to continue to be educated. And my lord, going back to the withdrawal agreement and the rights that are in fact in issue, page 63 of the authority's finding. In my submission, one of the fundamental areas the Upper Tribunal fell into was applying village to a provision that the court in village had simply not considered, Article 24.2. And when one looks at the text of Article 24.2, it is very clear, and there is really no basis or reason for interfering with the clear test and text of Article 24.2. There is no ambiguity there.
Now, can I ask you about one thing? You say, well, 24.2 reflects 12.3 of 2004-38. So let me just turn that back up again, which is page 26, isn't it?
My lord, yes.
There is a difference in wording, but I think you're going to say it isn't a difference that matters.
No.
So if you go back to Article 12.3, that says departure or death shall not entail loss of the right of residence. You're going to be no worse off.
Yes.
When you come to 24.2 of the withdrawal agreement, it doesn't say you'll be no worse off. It says shall have the right. So it's expressed positively.
My lord, yes.
But I think a little while ago you were saying it isn't to be supposed that the withdrawal agreement was going to give rights that hadn't pre-existed. So you don't suggest that difference in wording is significant.
My lord, no. The substance is exactly the same.
Yeah.
And when one looks at the content of Article 24.2, one can see that built into the language and the test, to put it that way, is a prior right of residence. Because you have to be the direct descendant of a worker who has ceased to reside in the host state. But my lord, even if there are differences, those differences have no impact on this appeal. The appellant and her circumstances would come within 12.3 as they do come within 24.2 read with 25.2.
And I follow that argument, but in that sense, any lack of ambiguity in 24.2 isn't at the heart of it, because we're really dealing with what the position would be under EU law, where you say the key provision is 12.3 of 2004.
My lord, yes, and that's only referred to because the reasoning of the Upper Tribunal and the submissions of the Secretary of State require the appellant to address that. But really what the appellant says is apply 24.2 and 25.2. That is what the ground of appeal is, before the Upper Tribunal, and 25.2 and 24.2, which have to be read together, are very clear. And the Upper Tribunal did not say that the appellant did not come within the text of it. What the Upper Tribunal said was, you can't get a right from it because of the reasoning in Village, which is that if you have a domestic law right, you cannot benefit from this right. So the Upper Tribunal did not conclude that the appellant did not fall within 24.2, and by extension 25.2. What the Upper Tribunal said was, well, it's irrelevant because you've got a domestic law right to reside here, and therefore you cannot benefit from this right. And of course, the extension of the comparison of the provisions is when one compares 24.2 with Article 10 of 492/2011, they're entirely different provisions. And then one has to compare Article 24.2 with 24.1h and ask the question, if 24.2 is simply 24.1h or Article 10 of 492/2011 in disguise, why is it there? Why do you repeat yourself? What is the need to repeat that right when it is set out generally in 24.1, specifically in 24.1h? Well, 24.2 is unnecessary, and it's entirely, my lord, the language is entirely inconsistent with the Article 10 of 492/2011.
So can I just try unpacking a moment? You've referred us to Article 12 of 2004, which you say is the precursor of 24.2 of the withdrawal agreement. And then you've also referred us to the Baumbast-Ibrahim line of authorities, which you say isn't anything to do with Article 12 of 2004. It goes back to Article 12 of 1968 and more recently Article 10 of 2011.
Oh, yes.
And in that context you say, well, if we look at those authorities, they don't say anything about needing to leave. Now, supposing for a moment you're right about that, do those authorities matter if you're right in saying that 24.2 goes back to Article 12 of 2004, which isn't anything to do with Ibrahim and Baumbast, you say?
My lord, no. If the appellant's primary submission is good, one doesn't need to go to the secondary submission because
Yes,
those cases relate to different rights. And so the primary submission is that this is a straightforward case because everybody has been under a misapprehension as to, including myself, as to 24.2 and 25.2. We weren't even looking at 25.2 at the Upper Tribunal. But 24.2, all parties proceeded on the basis that 24.2 essentially implemented in the withdrawal agreement the rights flowing from Baumbast-Ibrahim Texera. But if that was an error, and in fact 24.2 and 25.2 relate to 12.3, one simply doesn't have to look at the Baumbast-Ibrahim Texera line of cases. One doesn't have to look at Village because it is all irrelevant.
What's the problem with the suggestion that Article 12.3 of the 2004 directive, in referring to not losing a right of residence, is implicitly acknowledging Article 12 of 1968 as interpreted by Baumbast and those other cases? So in other words, it's the right that is not being lost is the right that exists because of 1668 Article Regulation 12 plus Baumbast.
But if one goes back to the reasoning of the Court of Justice in Ibrahim and the Advocate General's opinion in Ibrahim, which I referred my lords to earlier, I think it is clear from that judgment and the Advocate General's opinion that Article 12.3 was an extension of those rights, a strengthening of it, to those that it didn't apply to under 1612/68 and 492/2011.
The strengthening was by continuing, wasn't it?
Strengthening was by widening the application because it's beyond. It doesn't just apply to workers. It applies to self-employed people and anyone that benefits from a right of residence under the directive. But it's a more restrictive right than the 492/2011 right because it requires departure. One cannot, so a worker cannot say, well, my children are in education, I'm going to stay here.
Could we go back? I know we're going back. Could we
Yeah.
go back to the specific passage in Ibrahim,
Yes.
which
certainly.
you say responds to my Lord's point?
So, my Lord, if page 130 of the authorities bundle, we have the Advocate General's opinion. And it's paragraphs 29 to 32, and I think 32 in particular.
It was the passage. Was it the passage in the middle of 32 that you relied on?
My Lord, yes, next to C on the side of the page at 131, that strengthened the right of children of other Union citizens to continue their education in the host member state in certain circumstances.
But I was focusing on the words "to continue in certain circumstances," which is what it might be said 12.3 does. It says you have this existing right, you're not losing it even though the worker has now left the UK.
My Lord, yes,
State.
yes. I think that is the way it will inevitably apply, because if the worker has left, that means the worker was there previously and he was a worker. By being a worker, he had a right. Leaving means that the child's right now continues under 12.3. So it would be a continuation for the child, I think, in every case, and certainly in this case it was.
Well, the parent, the primary carer, already also had a right.
My Lord, not in this case.
No,
in many
but
cases it would.
that's because of the confusion as a self-employed person.
No, even then, because the primary carer here is, and this is because of the width of protection afforded by community law in these circumstances. So the child in question is the child of the appellant and her former partner, but the Union citizen in question is the partner of the appellant's former partner. And so the stepchild, the child in question here is the stepchild of the Union citizen.
Yeah, so the rights we're talking about only come into existence because of the happenstance that the father remarried.
My Lord, yes.
And you say, actually, it's more than that. The right only comes into existence because the father remarried and then that person left the UK.
My Lord, yes. So it's a very narrow class of case. The Baumbast line of case is a very broad, Baumbast, Abraham, etc., a very broad right granted only to workers. The rights granted under 12.3 are much narrower, require departure. And of course that presupposes either a breakdown in the family or the family being separated for other reasons, economic or otherwise.
And just looking at 12.3, is this right that if we go, but 12.3 on the facts of this case cannot take you back to Baumbast in the sense that the mother will not have had a Baumbast right that could have been preserved? The child didn't need Baumbast, I think, or did the child need Baumbast? But at any rate, the child's right was preserved. But from the point of view of the mother, we're not dealing with a pre-existing Baumbast right.
We're not, because we're dealing with Article 25.2 of the withdrawal agreement. If we were dealing with Article 25.1 of the withdrawal agreement, then we would be going back to Baumbast.
Yes, I think.
And the appellant would say that she would meet those requirements as well.
Yes, I follow that.
But of course, then the additional complication, which is addressing the argument raised by the Secretary of State that there isn't a requirement that there must be a compulsion to leave, that complication needs to be addressed. But of course, the appellant says that that is addressed, and the appellant says that she is right. Well, she says she's right on that, and that when one looks at the case law, there is nothing in the case law that incorporates a test that you must establish that you would be compelled to leave. In fact, the facts in Baumbast suggest that there was never any such intention, and both rights would coexist.
But on your primary case, which says 24.2 has nothing to do with Baumbast, the compulsion question really arises in the context of construing Article 12.3 rather than by reference to constraining bombast Ibrahim or whatever.
I'm sorry, my lord, I didn't follow that. We say that 12.3 doesn't have any compulsion tests.
No, quite.
Yes.
But that question has to be addressed in its own terms rather than by reference to bombast Ibrahim.
Absolutely, my lord. Because 12.3 is a legislative act. It's the European Union deciding to legislate. This is a right that is now going to be granted. One cannot qualify that right by reference to prior cases and interpret that right in the light of those cases, because it's a new right. And one can see from the Court of Justice's decision in Ibrahim that the intention of the directive overall, and references made to the case of Metok, which clearly set this out, was to strengthen rights, and therefore one cannot derive less after the directive than one had before the directive.
So insofar as it's relevant to consider 12.3, going back to a question we asked some time ago, which is, where is the right of residence granted to a parent, which is being where is the grant of the right of residence, which is the loss of which is being discussed in 12.3?
My lord, the answer to that is, in my submission, that 12.3 grants the right, but the language used, because it's the difficulty with the way 12.3 is drafted, is it's doing two jobs in one. It's referring to the right of the child and the right of the primary carer. And that is not unusual. If one looks at the directive, that is the way that it's drafted. And if my lords would like, I will dig up that case where Lord Justice Sedley describes the drafting methodology is aspirational rather than legislative. And so one has to look at the substance. And the substance clearly is, you're retaining a right if you're the child, but you might be retaining as a primary carer, you might be getting a fresh grant as a primary carer.
I mean, that isn't what it says, is it? The language of the directive does not refer to grant at all. It implies a pre-existing right,
absolutely,
which is not lost on the departure from the.
That is the language, my lord. I accept that. That is the language, but one has to interpret it in a purposive way, which is the way that EU rights have always been interpreted. And if one is not to interpret it in the way that a right is granted, one undermines the effectiveness of the provision completely. Because in a case such as the appellant's, we have a right granted to the child, the provision recognising that that right requires a right to the primary carer, which is consistent also with the line of authority in Baumbast and Zambrano. But then one doesn't have a grant because the primary carer didn't previously have a right, and that would undermine the effectiveness. And there are a number of Court of Justice cases that says that you cannot interpret such a right restrictively and undermine it, deprive it of its effectiveness. And what the appellant's submission and my submission is strengthened by reference to the domestic regulations that implement that right, which clearly, again, under the heading retention of right of residence, we looked at regulation 10.4, and that clearly grants a right. It doesn't talk about retaining a right that you had before. In the case of the child, yes, but not in the case of the primary carer.
Can I suspect I'll come up with facts that don't really work, but just to understand 12.3, if we go back to 12.3, so suppose we have a child here with the child's father, say, and the mother is not here. So at that stage, the mother isn't in the picture, the father dies, and the mother gets custody and wants to come here. Can she come here under 12.3?
My lord, yes, because there is a right if she has custody of the child. And that is precisely the situation that the directive would, in adopting the reasoning in Baumbast, Abraham, etc., and a host of other cases about ensuring that there is no disincentive to freedom of movement, entirely the type of scenario that the directive would be anxious to protect. Because otherwise...
So in your case, the mother doesn't have to have had doesn't have to have had any pre-existing right of residence at all, or necessarily even to have been in this country. You say Article 12.3 means that the child's right, it carries with it the right for the mother to come here.
In the words of Baumbach, by necessary implication, because otherwise that child's rights are entirely ineffective.
Is there any authority of the CJEU
On 12.3, my lord.
to support your interpretation of 12.3?
My lord, I don't know that there is any authority at all on 12.3, which is why there is no authority in the authorities bundle. My learned friend might disagree, might be able to assist the court, but as far as I'm aware, the provision has not been the subject of consideration.
Now, I follow all that. The way you were explaining it a moment ago, you were talking about necessary implication. Now, necessary implication does sound like Baumbach or Ibrahim or even Zambrano, albeit in a different context.
My lord, yes. I take support from that line of reasoning because one can see from Ibrahim that 12.3 was brought into the 2004 directive to extend, in certain circumstances, the protection already afforded to the families of workers.
Yes, I see. So we might end up back at Baumbach, Ibrahim that way, looking for parallel reasoning.
My lord, yes.
Yes, I see.
But we would say it's not necessary because the language of 24.2 and 25.2 is so clear. And of course, there is no dispute that the appellant comes within, but the Upper Tribunal did not decide it on the basis that they don't come within the language of the relevant provisions.
Can I just see how these fit together? If we were against you on your interpretation of 12.3, we were to conclude that 12.3, the right being retained, is the right that's being granted under Article 12 of the 68 regulations as interpreted by Baumbach. If that was our conclusion, then you couldn't get past that, could you? Because you would have to accept that under that route, self-employed people are not included.
But my lord, we would look at it the other way round and say that one starts with 24.2. And so whatever the court's interpretation of 12.3 of the directive, if 24.2 is broader, it is 24.2 that applies to the appeal, the right of appeal before the Upper Tribunal.
But 24.2 doesn't do anything other than already existed under European law, I thought you said.
Well,
That's your principal case, isn't it? It's not a new right.
It's not a new right.
Miss
but
Smythe
that
is wrong, you say.
My lord, yes, but if one is looking at the language and one doesn't have any assistance on 12.3 and the court decides, well, 12.3 ought to be interpreted in this way, but the withdrawal agreement has implemented it in this way, the right of appeal before the Upper Tribunal is that the refusal was contrary to 24.2 or 25.2 of the withdrawal agreement. So that is the focus of the appeal. The other provisions are there to aid in interpreting 24.2 and 25.2 if such aid is necessary. The appellant's primary case is it is not necessary because the provisions are clear. But if one has to, then...
Going right back to me, your case is 24.2 is not a new right, and therefore 25.2 is not a new right. It's a restatement of existing rights, which is what you would expect the withdrawal agreement to do. That's
My
your
lord,
case.
yes. But one cannot read that right down by reference to the interpretation of the prior right.
Why not?
Because it is 24.2 and 25.2 that is in effect. That is the law that the court needs to.
Forgive me, but if you're conceding that the rights retained or continued by the withdrawal agreement can be no more than the rights existing under EU law. It's not a question of reading down, is it?
My lord, no. It's
It's not an interpretation. Forgive me. I'm sorry for interrupting.
No, not at all, my lord.
It's not a question of how one interprets the language. It's a more fundamental than that. It's what you say the withdrawal agreement is.
My lord, yes. But the withdrawal agreement is a different piece of legislation, and it might well be that the withdrawal agreement, perhaps without applying its mind to it, has given broader rights. We don't say that it has, but if the court considers that it has, one cannot read those rights down by reference to the prior provisions. What is in effect at the moment in law is the withdrawal agreement.
So
The appellant's case.
If it's inadvertently, my word, not yours, if it's inadvertently, through its phraseology, created wider rights than it intended, that's where we are. Is that the case? Those are the rights which exist.
If one gets there, my lord, and of course to get there one would have to interpret 12.3 in that way without the aid of any prior case on it, and one would be interpreting 12.3 by reference to the language of
Withdrawal agreement.
retention.
But so what you're really saying is that inadvertently it has created new rights.
No, I'm not saying that, my lord. What I'm saying is that they are consistent with each other, and I'm saying that 12.3 of the 2004 directive cannot be interpreted in the way that it cannot be interpreted restrictively. It must be given its purpose must be given effect to. It cannot be undermined in terms of the effectiveness of the protection it provides. The purpose, which is referred to in Ibrahim, is clearly to strengthen rights. If one looks at the particular language used in the context of a directive that is not entirely careful about the use of language, for example, one has the use of the word child in circumstances where the person being referred to is not a child in the sense of being under the age of 18. Some provisions are not defined and not used consistently across the directive. It's something that I could provide a post-hearing note on if it would assist the court. It's not something that, and I was discussing with my learned friend, it's a very unusual situation to be before the Court of Appeal without having any of these arguments tested before, because everyone got it wrong before. But it might be that there is some assistance to be derived from that. And if that is what the court would like, I'd be happy to do it.
We've hit 1 o'clock, so we're going to break. Subject to the point you're just talking about, are you really at the end of your submissions? Or is yes, I see. I don't know whether you can achieve anything over lunch in terms of this point you've just been raising. So I won't ask you to formally close your opening submissions at this stage. If you, by 2 o'clock, have got any further, you could pass on what you have found.
I'm grateful, man.
So, right, disabled.